Hey guys, AJ here coming at you with some more IP. Welcome to week 2, and this video really is to just draw to your attention some of the main points that I want you to pick up on from this week's reading in Fitzgerald and Eliades. This week we are looking at copyright, which is one of the main forms of IP. It's pretty much everywhere you look nowadays. It's pretty much in everything you consume as a modern pop culture consumer. And it's becoming increasingly relevant when you're talking about litigation. The first thing I want to draw to your attention is the split in the legislation. So the Copyright Act is obviously all about protecting copyright, but there are two main forms or groupings of items that copyright will attach to. And the first grouping that you need to know about are what we call original works, okay? These are literary, dramatical, musical, and artistic works, alrighty? You've probably listened to some, read some, otherwise consumed some, even in your everyday movements today. So they're the probably main forms of copyrightable item, and you'll see that because of the nature of these different works, they can overlap with each other. And this is the thing about copyright. You can actually have one item that has many different and separate copyrights attached to it. And those copyrights might be owned by the same person, or they might be split and actually owned by a number of different people. So you might have a music CD. For those that don't know what this is, it is a CD. On that CD, I might have composed a song. So I own the copyright in the lyrics to that song. My friend may have composed the melody, and in which case that will be a musical work. So she will own copyright in that musical work. I'll own the copyright in the literary work, the lyrics. And we may then either publish it ourselves, or if we go to a recording label and record that song, the music label will own copyright in the sound recording. And then, to make it attractive for purchase, we may cover it up with an album cover with something beautiful, perhaps like this. And there you will have copyright in the artistic work that goes into making the cover for the CD. That technology is a little outdated, but it's just really to show you the way that copyrights can overlap. So they're copyrightable works. Then the other split in the legislation, the other part of the legislation, covers subject matter other than works. And here we have sound recordings, TV broadcasts, sound broadcasts, things like published editions, okay? So a different kind of intellectual endeavour or creative endeavour involved here, a little bit perhaps more technical. And you have different rights that attach to works, literary, dramatic, musical and artistic works, and a different set of rights again that attach to part 4, subject matter other than works. You'll find different durations and different actual rights that are attaching to the copyright in that item. Okay, so there's the first thing I wanted you to note, was the split in the legislation and the two different groups of items that can be covered by copyright. The next thing to note is the idea-expression dichotomy. And here it's all about preserving that all-important public domain. We're going to hear a fair bit about the public domain here, or what is more recently called the Creative Commons. We need to ensure that there is enough out there, freely accessible, freely available, the common kinds of words, ideas, things that you use in everyday speech and life. It has to be out there for all to use freely. So you can't go fencing off little pieces of the public domain to private ownership. Otherwise, we'd be left with not a whole lot to play with. Okay, so the idea expression dichotomy really is about protecting the public domain. So, for example, you couldn't copyright the words mobile phone because everybody needs to know what a mobile phone is, and you need to be able to tell other people that you have a mobile phone. Okay, so there is the idea expression dichotomy. Now, for those of you that are on Twitter, you'll see that I tweeted this week a rather sensible decision by a German court, and someone wanted to copyright the word hashtag tweet. Yep, that's it, hashtag tweet. Obviously, that kind of thing, it communicates an idea. If I want to tweet you, I'm going to use the word tweet. Just putting the hashtag in front of it doesn't change it from being representing an idea to suddenly a copyrightable work. The other thing that I want to draw to your attention is the requirement of material form. So here, copyright has to be fixed, and it has to be something that you can refer back to later, okay? Because if you're going to get, for a work, around 70 years worth of legal protection, you can't have something that's going to be there one day and gone the next, okay? So, for example, there's a fairly famous anecdote that they tend to use in Europe where some people tried to copyright a light show that was performed in Paris, and they shone all these different lights on the Eiffel Tower, and it all looked very glorious and pretty. That kind of thing is what we call ephemeral. It's there and then it's gone. Okay, you can't claim copyright in something that's going to be gone tomorrow. I think there was another example where people were fighting over the display of fireworks from the Sydney Harbour Bridge for New Year's Eve. Again, it's there one minute, it's gone the next. You can't copyright something like that. Okay, so the spoken word, if it's not being recorded in any way, just me speaking to you, I can't then later on claim copyright in the words that are kind of still floating in the air, okay? Again, also things like impromptu jazz, for example, music that just comes out of a performer creatively, isn't recorded, it's just they're going with the flow. Again, that's not going to be something that's copyrightable, okay? So it needs to be fixed into material form in order to get you a very substantial period of copyright protection. The other thing is originality, and here we have, again, a hark back to the idea of hashtag tweet. You need to actually invest in your copyrightable work a certain amount of, shall we say, creative spark. There was a time when originality was really just considered to be sufficient sweat of the brow, if you will. But now, particularly since the ICE TV case, we're really looking for that little modicum of creativity, as they'd say in the US courts. Or I think the courts here said that labour and expense is not enough. There has to be some kind of creative spark. Okay, so hashtag tweet, no creative spark there, really. There's also been a number of different cases that have tried to copyright things perhaps a little longer than just the one word, like a title. There was a rather scathing review of some resorts a few years ago, and they used the slogan, the resort that offers precious little, burn, burn. You couldn't copyright that because really there's no spark of creativity in there. What you're saying is there's a resort, my experience wasn't particularly pleasant, precious little. Okay, so it has to be something with that little tiny spark of creativity. When you're talking about compilations, and you'll notice this from Fitzgerald and Eliades, they really kind of creep closest to the line in terms of having that original component to them. And there have been some cases which kind of make you scratch your head and go, where is the creativity in that? I mean, there has been held to be sufficient creativity in things like planning out an accountancy ledger where the columns were on one side and they were headed in a certain way. You need to be able to convince a court that there has been some kind of intellectual endeavour that's gone into the exercise. Okay, so have a little look at that. Keep the idea of originality in mind. The other thing that I want you to note from Fitzgerald and Eliades is infringement. And here we come to, I guess, the crux of IP rights. If I own copyright in a work and you reproduce that work without my permission and without any payment or other form of gratuity to me, I can sue you for copyright infringement. And here is really the big bogeyman of IP. People are very wary of IP because they feel that the whole threat of infringement that kind of hangs in the background to copyright rights and other intellectual property rights really does scare a lot of people away from what is and could be considered productive use of those copyright items downstream in the marketplace. So where you've got things like, as I mentioned in my other video, musically, where the kids are all making mashups and using copyright works to mix with each other and new visuals, speeding things up, slowing things down. We tend to think of this as a legitimate use of usually copyright musical works and visual works that are out there perhaps on YouTube, for example. Should there be that threat of infringement in the background? I mean, this is something I want you to think about fairly carefully this term, and it's one of the reasons why I've got the Week 8 presentations on fair use. It's a really hot topic right now, and it's really important to a whole lot of creators that are out there downstream in the marketplace wanting to use the copyright material that's out there in public view. So in order to infringe a copyright work, you need to have a reproduction of that work or an adaptation. Okay, there has to be something that makes you realise, oh, hang on a minute, I think I've heard, seen, read that before, and it has to be a substantial part. And here is, I guess, a really nice tie-in to the articles that I have listed for you in relation to poor old Greg Ham and the Men at Work copyright infringement of the old Kookaburra Sits in the Old Gum Tree song. And it's a really, I guess, tragic tale of copyright infringement pursued beyond what was warranted, perhaps. I don't know, you go figure. Have a little look at the article, but just for your own reference, here Kookaburra sits in the old gum tree is the original song. Here is the Men at Work version. You figure that out for yourself, but certainly whether it was infringement or not infringement, I don't think the kinds of damages that were sought in that case were warranted. Certainly the judge didn't think that they were warranted. But what went above and beyond the issue of damages there was the reputational harm. And this is what really ate away at Greg Ham after the case. And ultimately, poor man took his own life. So a tragic tale, like I said, something I want you guys to make your own minds up on. And fair use comes hot on the heels of that whole kind of discussion. So at the moment, we only have in the legislation what we call a fair dealing exception to copyright infringement. And if you're going to argue fair dealing, it has to be for one of the specified purposes that are set out in the legislation. So you can't just say, oh yes, I infringed, but it was fair in the context that I used it in. Okay, it has to fit within one of those enumerated purposes in order to satisfy the legislation and get you off the hook effectively. Okay, what's being argued now, since the ALRC kind of first brought this issue to the fore, is that we should just have a fair dealing excuse. Like I said before, I think my dealing with this particular work was fair in the context that it was used in, and you shouldn't have to necessarily hang your hook on one of a set of enumerated purposes for that fair dealing to apply. There is a great little video up on YouTube on fair dealing, and here is the link. I think Tara really discusses the whole issue very clearly, fairly concisely, and if you're thinking about doing the Week 8 presentation or you've already put your name down for it, I'd highly recommend that you go ahead and have a little look at Tara's video there. So that's probably all I wanted to say in relation to copyright. They're the big ticket items that I want you to take away from your reading this week. For those that are really keen, go ahead and have a look at the designs chapter as well. Really, all we need to say about designs can be summed up pretty easily. They are specifically intended to cover the visual features that have been applied to an item that has been put out in industry, so industrially manufactured or industrially applied. Okay, so it might be a creative work, however, it's intended specifically to be mass produced. And so you've gone really from that typical idea of a creator creating a way in their studio to make something of interest, beauty, appreciation, to something that is intended for mass consumption. Okay, you're going to get your 10 years and that's it. That's all she wrote for designs. Okay, now obviously if you've got, say, a drawing of a shoe, that's more than likely going to be copyrightable if the shoe has your little creative spark inherent in the drawing. If you, for example, create a type of shoe with specific visual features, maybe beautiful, maybe not, then if that shoe is going to be manufactured according to your design, that's typically the kind of thing that you'd be looking for designs registration of. Like I said, 10 years and you're all done and dusted. That's all you get. Anyway, that's designs in a nutshell, very rapid nutshell. And if you have any queries or questions, just let me know. We can catch up in the Zooms. Other than that, post your queries to the forums. And if you like this video, give it a big thumbs up and subscribe. And I hopefully will chat with you next week. Thanks, guys. Bye.